Trial before a court of session. Session trial. Trial is an important process to determine whether the accused is guilty of an offence. Basing on the seriousness of the offence, criminal cases are categorized under two heads: summons case and warrant case. Among warrant cases, the cases which are more serious in nature are triable by court of session, while the lesser serious cases are triable by court of magistrate. Column 6 of the first schedule of the Crpc. A court of session cannot take cognizance of any offence directly, though it is triable by it. A competent magistrate takes cognizance of any offence and commits the case for trial to a court of session under section 209. Trial of criminal cases may be explained with reference to the following heads: trial of warrant cases before a court of session, trial of a warrant case by magistrate, and trial of summons cases by magistrate, and summary trial. There are four types. That means trial of warrant cases before a court of session, that is the highest. Then trial of warrant cases by magistrate, next lower level. Then trial of summons case by magistrate, still lower level. Then finally summary trial, lowest level. This lecture deals with trial before court of session and trial of warrant case by magistrates, trial of summons case by magistrates, and summary trials as discussed in the lectures 16, 17, 18 respectively. Now trial before a court of session. Chapter 18, containing sections 225 to 237 of the Code of Criminal Procedure, lays down the provisions relating to trial before a court of session. Section 225 provides for trial to be conducted by public prosecutor. Section 226 authorizes the public prosecutor to open the case. Section 227 empowers the judge to discharge the accused if he considers that there is no sufficient ground for proceeding against the accused. Section 228 empowers the judge to frame a charge after considering the records and documents of the case and hearing the argument of both the sides. Section 229 empowers the judge to convict the accused on a plea of guilt. Section 230, judge shall fix a date for examination of witnesses if the accused refuses to plead or does not plead or claims to be tried. Section 232 provides for acquittal of the accused. Section 233 empowers the judge to call upon the accused to enter upon his defense if he is not acquitted. Section 234 deals with arguments. Section 235 empowers the judge to give judgment of acquittal or conviction. Section 236 provides for a form of trial in respect of previous conviction. 237 prescribes the procedure to be followed by a court of session for trial of cases relating to offences of defamation against high dignitaries and public servants. The code lays down the procedure for trial before a court of session as follows. 1. Parties. In a trial before a court of session, the prosecution shall be conducted by a public prosecutor as per section 225. Public prosecutor means a person appointed under section 24 of Crpc and includes a person acting under his direction, that is assistant public prosecutor, act like that. The accused has a right to engage a counsel, a defense counsel of his choice. If he cannot afford to engage a defense counsel, the court engages at the state expenses. Before commencing the trial, the accused is supplied with copies of documents, that is police report, FIR, statement recorded by police, etc. Next, opening the case, section 226. The public prosecutor opens the case by describing the accusation against the accused. He states briefly by what evidence he proposes to prove the guilt. The prosecutor's duty is not to secure a conviction, but simply to lay the facts of the case before the tribunal, who is to judge. It was held in Hukam Singh vs. State of Rajasthan 2001 that section 226 CRPC, the public prosecutor has to state what evidence he proposes to adduce for proving the guilt of the accused. If he knew at that stage itself that certain persons cited by the investigative agency as witnesses might not support the prosecution case, he is at liberty to state before the court that fact. Alternatively, he can wait further and obtain direct information about the version which any particular witness might speak in court. If that version is not in support of the prosecution case, it would be unreasonable to insist on the public prosecutor to examine those persons as witnesses for prosecution. Next, discharge of the accused, section 227. After hearing from both parties, prosecution and defense, if the court considers that there is no sufficient ground to proceed against the accused, discharges him and records the reasons for doing so. There is no scope for examination of any witness, but there is scope for both sides to argue their case in favor of framing a charge or discharge. Charge or discharge. Now, T.V. Sharma versus R. Miraya, 1980, AP. In this case, a full bench of AP High Court held that the sessions judge is bound to discharge the accused if he considers that there is no sufficient ground for proceeding against the accused. in Niranjan Singh Karan Singh Punjab versus Jitendra Bhimaraj Bajja, 1990. The Supreme Court has held that at the stage of framing the charge, court is required to evaluate the material and documents on record with a view to finding out if the facts emerging therefrom, taken at their face value, disclose the existence of all the ingredients constituting the alleged offence. In finding out a prima facie case, not only the first information report or complaint, but even the statement of witnesses recorded under 161 Crpc during investigation are to be taken into consideration by the court. Case Muhammad Akil versus Delhi, 1988. It was held in Ramdev versus State of Rajasthan, 1994, that in view of Section 227, the court, before passing an order of discharge of the accused, must consider the records and documents in the case. Next, framing of charge, Section 228. Section 228 of the Code provides for framing of the charge. It runs as follows. If, after such consideration and hearing as aforesaid, the judge is of the opinion there is ground for presuming that the accused has committed an offence which A. is not exclusively triable by the Court of Session, he may frame a charge against the accused and by order transfer the case for trial to the Chief Judicial Magistrate or any other Judicial Magistrate of first class and direct the accused to appear before the Chief Judicial Magistrate or the case may be Judicial Magistrate of the first class on such date as he deems fit, and thereupon such magistrate shall try the offence in accordance with the procedure for trial of warrant cases instituted on a police report. B. Is exclusively triable by the Court of Session, he shall frame in writing a charge against the accused. Next, where the judge frames any charge under Clause B, subsection 1, the charge shall be read and explained to the accused, and the accused shall be asked whether he pleads guilty of the offence charged or claims to be tried. After hearing from both the parties, prosecution and defence, if the court presumes that the accused might have committed the offence, it frames a charge in writing. If the offence is exclusively triable by a court of session, if the offence is not triable exclusively by Sessions Court, it frames the charges and transfers the case to Chief Judicial Magistrate. Explaining the charge and inquiry about the plea, Section 228, Clause 2. The contents of the charge have to be explained to the accused so as to enable him to plead guilty of the offence or claims to be tried. In Soma Chakravarti vs. State 2007, appellant or accused was charged with fraud and misappropriation of a huge amount of government money. The accused dishonestly processed and verified fake bills. The bills in question were neither raised nor signed by the appropriate authority. Bills were not entered in bill register. It was held that where the accused appellant, who was never assigned any duty in respect of processing or signing the bills in question, which were neither raised nor signed by appropriate authority, dishonestly processed and verified them in connivance with the other co-accused to cheat respondent corporation. Therefore, the order framing charges against her on the basis of material available on record would be proper. It was also held that presence of material on record was sufficient for court to form an opinion that accused might have committed offence and what would be enough to frame a charge. Next case, in Sanghi Brothers Indore Private Limited versus Sanjay Chowdhury 2009, accused had taken motor vehicles on lease from complainant. Accused failed to pay rent and sold some vehicles. Security given for due performance of agreement was found to be the property of some other person. It was held that framing of charge on suspicion about commission of offence and involvement of accused was sufficient to frame charge which was not improper. Next, conviction on plea of guilty 229. If the accused pleads guilty, the judge shall record the plea and may in his discretion convict him thereon. The judge also has a discretionary power whether to convict him or to proceed with the trial. But it is better to proceed with the trial. Next, date for prosecution evidence, Section 230. If the accused refuses to plead or does not plead or claims to be tried or is not convicted under 229, judge shall fix a date for the examination of witnesses or may order for compelling appearance of any witness or production of a thing or a document. Next, evidence for prosecution, Section 231(1). On the date so fixed as above, the judge takes all such evidence in support of the prosecution. The judge may, in his discretion, permit the cross-examination of any witness to be deferred until any other witness or witnesses have been examined, or recall any witness for further cross-examination. It was held in Pirti versus State of Haryana, 1993, that the prosecution is not bound to produce all the witnesses said to have seen the occurrence. Material witnesses considered necessary for prosecution of unfolding a prosecution story alone need to be produced without unnecessary and redundant multiplication of witnesses. In Vijayan versus State, 1993, a woman was sleeping along with her husband in a room. She was awakened by the accused in the night and was taken away to a place not very far away from the room and was raped by 3 persons. The first information report was lodged after 2 days. During trial, her husband was not examined as a witness before the court. It was held that failure to examine her husband before the court to corroborate her evidence is certainly fatal to the case of prosecution, and in any event, adverse inference can be drawn. Similarly, non-examination of the investigating officer results in denial of an opportunity to the defense to test the veracity of the prosecution and its witnesses. In such case, conviction cannot be sustained. Case relevant is Hazari Chaube versus State of Bihar, 1988. Next, arguments of the prosecution, section 314, clause 2. The prosecution, after close of witnesses, submits a memorandum of his oral arguments. A copy of the same is supplied to the opposite party. Examination of accused. It is to be made without administering oath. It is to give an opportunity to him to explain the circumstances alleged against him by the prosecution. That is, not without oath, not under oath. Next. Acquittal, section 232. After hearing from both the parties, if the judge considers that the accused has not committed the offence, records an order acquitting the accused. Section 232 runs as follows. If, after taking the evidence for prosecution, examining the accused, and hearing the prosecution and defence, hearing the defence on the point, the judge considers that there is no evidence that the accused committed the offence, the judge shall record an order of acquittal. Shall record an order of acquittal. Difference between discharge and acquittal. Following are the notable points of distinction between discharge and acquittal. Discharge. In discharge, there is no prima facie case made out against the accused. In acquittal, there is a prima facie case made out against the accused. In discharge, an accused who is discharged may again be charged with the same offence under section 437. In the case of acquittal, an accused who is acquitted cannot be put on trial again for the same offence for which he has been acquitted. Section 403. Discharge. An order of discharge is not a judgment. Acquittal. An order of acquittal is in the nature of a judgment. Entering upon defence. Section 233. If the accused is not acquitted, he shall be called upon to enter on his defence. The court may summon or examine at any stage any person as a court witness. Section 233 runs as follows. Where the accused is not acquitted under section 232, he shall be called upon to enter on his defence and adduce any evidence he may have in support thereof. If the accused puts in any written statement, the judge shall file it with the record. If the accused applies for the issue of any process for compelling the attendance of any witness or production of any document or a thing, the judge shall issue such process unless he considers, for reasons to be recorded, that such application should be refused on the ground that it is made for the purpose of vexation or delay or for defeating the ends of justice. Next, argument, section 234. After recording the defence, the prosecutor sums up his case, and accused or his pleader, defence counsel, shall be entitled to reply. The prosecutor may be allowed to make a submission in case any law point is raised by the defence. Section 234 runs as follows. When examination of the witness, if any, for the defence is complete, the prosecutor shall sum up his case, and the accused or his pleader shall be entitled to reply. Provided that where any point of law is raised by the accused or his pleader, the prosecution may, with the permission of the judge, make his submissions with regard to such point of law. Judgment of acquittal or conviction, section 235. After hearing argument from both the sides, the court delivers judgment of acquittal or conviction. Section 235 runs as follows. After hearing arguments and points of law, if any, the judge shall give a judgment in this case. If the accused is convicted, a judge shall, unless he proceeds in accordance with the provision of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. Previous conviction, section 236. In a case where a previous conviction is charged under provisions of subsection 7 of section 211, the accused does not admit that he has been previously convicted as alleged in the charge. The judge may, after he has convicted the said accused under section 229 or 235, take evidence in respect of the alleged previous conviction and shall record a finding thereon. provided that no such charge shall be read out by the judge, nor shall the accused be asked to plead thereto, nor shall the previous conviction be referred to by the prosecution or any evidence adduced by it unless and until the accused has been convicted under section 229 or 235. Procedure in cases instituted under section 199 clause 2, that is section 237. A court of session taking cognizance of an offence under subsection 2 of section 199 shall try the case in accordance with the procedure for trial of warrant cases instituted otherwise than on police report before court of magistrate, provided that the person against whom the offence is alleged to have been committed shall, unless the court of session for reasons to be recorded otherwise directs, be examined as a witness with the prosecution. Every trial under this section shall be held in camera if either party thereto so desires, or if the court thinks fit to do so. Now, if in any such case the court discharges or acquits all or any of the accused, and is of opinion there was no reasonable case for making the accusation against them or any of them, it may by its order of discharge or acquittal direct the person against whom the offence was alleged to have been committed, other than the president, vice president, governor of a state or administrator of a union territory, to show cause why he should not pay any compensation to such accused or to each or any of such accused when there is more than one. Next, the court shall record and consider any cause which may be shown by the person so directed, and if it is satisfied there was no reasonable cause for making the accusation, it may, for reasons to be recorded, make an order that compensation to such amount not exceeding 1,000 rupees, as it may determine, be paid by such person to the accused or to each or any of them. Compensation awarded under subsection 4 shall be recovered as if it were a fine imposed by a magistrate. No person who has been directed to pay compensation under subsection 4 shall, by reason of such order, be exempted from any civil or criminal liability in respect of the complaint made under this section, provided that any amount paid to an accused person under this section shall be taken into account in awarding compensation to such person in any subsequent civil suit relating to the same matter. Next, the person who has been ordered under subsection 4 to pay compensation may appeal from the order insofar as it relates to payment of compensation to the High Court. Next, when an order for payment of compensation to an accused person is made, the compensation shall not be paid to him before the period allowed for presentation of appeal has elapsed, or if the appeal is presented before the appeal has been decided. Now, this is Sessions case complete. Trial of warrant case by magistrate. Warrant cases of less serious nature than that was tried by the Sessions case are tried by magistrates. Chapter 19, containing sections 238 to 250 of the Code of Criminal Procedure Code lays down the provisions relating to trial or warrant cases by magistrates. Section 238 speaks about compliance with Section 207. Similarly, Section 239 deals with when accused shall be discharged. Section 240 deals with framing of charges. Section 241 deals with conviction on the plea of guilty. Section 242 deals with evidence for prosecution. Section 243 deals with evidence for defense. Section 244 deals with evidence for prosecution. Section 245 deals with when accused shall be discharged. Section 246 deals with procedure when accused is not discharged. Section 247 deals with evidence for defense. Section 248 deals with acquittal or conviction. Section 249 deals with absence of complainant. Section 250 deals with compensation for accusation without reasonable cause. Then trial by magistrate in court may be subcategorized into three parts. 1. Cases instituted on a police report, that is sections 238 to 243. Then cases instituted otherwise than on a police report, that's section 244 to 247. And common provisions regarding conclusion of a trial, section 248 to 250. A. Trial of warrant case instituted on a police report, section 238 to 243. Section 2R of the code defines police report as a police report means a report forwarded by a police officer to a magistrate after completion of his investigation under subsection 2 of section 173 of the code. The trial of cases instituted on police cases may be explained as follows. 1. Supply of copies to the accused, section 238. When an accused is brought before a magistrate for trial, the copies of FIR, statement of persons recorded during investigation, are required to be supplied to him. The magistrate shall satisfy that the provisions under section 207 are complied with. Next, discharge of accused, section 239. After hearing from both sides, prosecution and defense, if the magistrate considers the accusation against accused as groundless, he shall discharge the accused and record reasons for so doing. The word discharge here means a discharge in relation to specific offence for which accused has been charged. An order of discharge cannot be said to be bad in law on the ground that section 217 was mentioned instead of 239 in the order of discharge. Case State versus WPF Roberts, 1988, Orissa. Section 239 should be read with Section 240, which provides for framing of charge. It is the duty of the court to frame the charges and consider over the matter judiciously. Next, framing of charge 240. After considering the matters, if the magistrate presumes that the accused has committed an offence and he, the magistrate, is competent to try it, frames in writing a charge against the accused, the contents of the charge are to be read over. Supply of copies to the accused, Section 238. When an accused is brought before the magistrate for trial, the copies of FIR, statements of persons recorded during investigation, are required to be supplied to him. The magistrate shall satisfy that the provisions under Section 207 are complied with. Next, discharge of accused, Section 239. After hearing from both sides, that is prosecution and defense, if the magistrate considers the accusation against the accused as groundless, he shall discharge the accused and record reasons for so doing. The word discharge here means a discharge in relation to the specific offence for which the accused has been charged. An order of discharge cannot be said to be bad in law on the ground that Section 217 was mentioned instead of 239 in the order of discharge. Case State versus Roberts. Section 239 should be read with Section 240, which provides for framing of charge. It is the duty of the court to frame the charge and consider the matter judiciously. Framing of charge, Section 240. After considering the matters, if the magistrate presumes that the accused has committed the offence and he, the magistrate, is competent to try it, frames in a charge in writing against the accused. The contents of the charge are to be read over and explained to the accused. He shall be asked whether he pleads guilty or claims to be tried. Section 240 not only authorizes the magistrate to consider the report and documents set along with it under Section 173, but also to examine the accused if he thinks it necessary. It runs as follows. A. If upon such consideration, examination if any, and hearing, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offence triable under this chapter, which such a magistrate is competent to try and which in his opinion could be adequately punished by him, he shall frame in writing a charge against the accused. The charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty of the offence and charged or claims to be tried. In M.A. Das and others versus State of Jammu Kashmir, 1981, the Supreme Court got the opportunity to examine Section 240 of the Code of Criminal Procedure, which deals with framing of charges. Supreme Court held that the trial court under this section frames charge after generally giving brief survey of the evidence which is sought to be adduced against the accused. The High Court adopts the same procedure. If the High Court does not go into details of the pros and cons of the matter, then it is not illegal because it is not the stage when the court should enter into meticulous consideration of evidence and materials. If a charge has been framed in such circumstances, Supreme Court will not interfere to unsettle it. Next, conviction on the plea of guilty, 241. If the accused pleads guilty, the magistrate shall record the plea and convict him. Examination of witnesses. If the accused does not plead or refuses to plead or claims to be tried, the magistrate shall fix a date for examination of witnesses and may issue summons to that effect. The magistrate shall record evidence and may permit any cross-examination or recall any witness. Evidence for prosecution, Section 242. The prosecution has to submit a memorandum of oral arguments and the accused shall be examined under Section 3131B. This section corresponds to clauses 6 and 7 to 51. An old code, but Section 2 is newly added. The subsection sets at rest the divergent views expressed by different high courts with regard to the duty or obligation of the court to summon any witness, even if asked by the prosecution, in a case instituted on a police report under Old 251A. The court under the present subsection 2 may, on application by the prosecution, issue summons to compel attendance of prosecution witness or to compel production of any document or anything This power may be exercised by the court suo moto. It seems the court may, where the prosecution is negligent or guilty of lashes, refuse to exercise this power. Cases Mangila, 1974. Section 242 runs as follows. If the accused refuses to plead, or does not plead, or claims to be tried, or the magistrate does not convict the accused, under Section 241, the magistrate shall fix a date for the examination of witnesses, provided that the magistrate shall supply in advance to the accused the statement of witness recorded during investigation by the police. The magistrate may, on the application of prosecution, issue a summons to any of its witnesses directing him to attend or to produce any document or other thing. On the date so fixed, the magistrate shall proceed to take all such evidence as may be produced in support of the prosecution, provided that the magistrate may permit the cross-examination of any witness to be deferred until any other witness or witnesses have been examined, or recall any witness for further cross-examination. Evidence for defense, Section 243. After completion of the above, the accused is required to produce his evidence. The magistrate, if necessary, may order production of such witness or things. Section 243 reads as follows. 1. The accused shall then be called upon to enter upon his defense and produce his evidence, and if the accused puts in any written statement, the magistrate shall file it with the record. 2. If the accused, after he has entered upon his defense, applies to the magistrate to issue a new process for compelling the attendance of any witness for the purpose of examination or cross-examination, or the production of any document or other thing, the magistrate shall issue such process unless he considers that such application should be refused on the ground that it is made for the purpose of vexation or delay, or for defeating the ends of justice, and such ground shall be recorded by him in writing, provided that when the accused has cross-examined or had the opportunity of cross-examining any witness before entering on his defense, the attendance of such witness shall not be compelled under this section unless the magistrate is satisfied it is necessary for the ends of justice. The magistrate may, before summoning any witness on an application under subsection 2, require that the reasonable expenses incurred by the witness in attending for the purpose of the trial be deposited in the court. In Venkateshwar Rao vs. State, 1979, AP, the High Court of Andhra Pradesh considered the words may require used in section 243 clause 3 and held that the requirement of depositing the expense of the witness could be insisted upon only in cases where the accused has the capacity or a means to pay the expenses. Sudhir Kumar Dutt vs. The Kind, 1944. It was held in this case that the magistrate has no discretion to refuse to issue a process to a witness unless he is of the opinion that it should be refused for any of the reasons specified in the section. Acquittal or conviction. If the magistrate finds the accused not guilty, he shall record an order of acquittal, and if the accused is found guilty, he is convicted according to law. Cases institute otherwise than on a police report. Next, 244 to 247. Section 244 to 247 of the Code deal with the procedure for trial of warrant cases instituted otherwise than on police report. In a trial of warrant case by a magistrate on a police report, the accused is charged or discharged after scrutiny of the documents submitted along with the charge sheet. But in respect of cases otherwise than on police report, that is on a private complaint, the charge is framed after recording evidence and after a cross-examination of prosecution witness by accused for 2 times, before and after charges. Procedure in respect of cases instituted otherwise than on a police report is explained below. 1. Evidence for prosecution. Section 244. When the accused appears on or is brought before a magistrate shall take all such evidence as may be produced in support of the prosecution. Section 244 runs as follows. When in any warrant case instituted otherwise than on a police report, the accused appears or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. The magistrate may, on application of the prosecution, issue a summons to any of its witnesses directing him to attend or to produce any document or other thing. Discharge 245. Section 245 makes provision as to when the accused shall be discharged. The magistrate may discharge the accused even before the prosecution evidence if he finds the case groundless. Section 245 runs as follows. If upon taking all the evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. Nothing in this section shall be deemed to prevent a magistrate from discharging an accused at any previous stage of the case if, for reasons to be recorded by such magistrate, he considered the charge to be groundless. Explaining charge and the plea of accused, section 246. Section 246 lays down the procedure where accused is not discharged. If a prima facie case is made out by the prosecution that the accused has committed an offence, the court frames charges against the accused. The contents of the charge are read over and explained to the accused so that he pleads guilty or claims to be tried. If he pleads guilty, he is convicted. The choice of accused to recall prosecution witness, section 246, 4 and 5. If the accused refuses to plead or does not plead guilty or claims to be tried, and he may be given an opportunity to cross-examine prosecution witness and the witnesses named by him may be recalled. Evidence for defense, section 247. Later, the accused is called upon to produce his defense evidence. Written statement, if any, by the accused is filed with the record. The court may also order production of persons as witnesses or things if required, acquittal or conviction. After hearing from both sides, if the magistrate finds the accused not guilty, he shall record an order of acquittal, and if the accused is found guilty, he is convicted according to law. Next, common provisions regarding conclusion of trial, section 248 to 250. Section 248 to 250 of the Code provide for common provisions regarding conclusion of trial. Section 248 provides for acquittal or conviction. Section 249 authorizes the magistrate to discharge the accused if the complainant is absent on the day fixed for hearing of the case. Section 250 provides compensation for accusation without reasonable cause. Now, acquittal or conviction, section 248. In every case where the charge has been framed, if the magistrate finds the accused not guilty, he shall record an order of acquittal, 248 clause 1. If he finds the accused guilty, pass a sentence according to law. Previous conviction. Where accused does not admit previous conviction, a magistrate, after convicting the accused, takes evidence in respect of the alleged previous conviction. Area, absence of complaint, 249. When the proceedings have been instituted upon complaint on any day fixed for the hearing of the case, the complainant is absent, the offence may be lawfully compounded or is not cognizable offence. The magistrate may, in his discretion, notwithstanding anything hereinbefore contained, at any time before charge has been framed, discharge the accused. Compensation for accusation without reasonable cause, 250. Section 250 empowers the magistrate to award compensation to the accused. Where accusation is made without reasonable cause, magistrate may acquit or discharge him or may also order such person making accusation to pay compensation, 250 clause 1. The amount of compensation shall not exceed fine, which the magistrate is empowered to impose. In case of default, such person has to undergo simple imprisonment for a period of not exceeding 30 days. Section 250 runs as follows. Section 250 runs as follows. If in any case instituted upon complaint or upon information given to a police officer or to a magistrate, one or more persons is or accused before a magistrate of any offence triable by a magistrate, and the magistrate by whom the case is heard discharges or acquits all or any of the accused, and is of the opinion that there was no reasonable ground for making the accusation against them or any of them, the magistrate may, by his order of discharge or acquittal, if the person upon whose complaint or information the accusation was made is present, call upon him forthwith to show cause why he should not pay compensation to such accused, or to each or any of such accused when there are more than one. If any such person is not present, direct the issue of summons to him to appear and show cause as aforesaid. The magistrate shall record and consider any cause which such complainant or informant may show, and if he is satisfied that there was no reasonable ground for making the accusation, may, for reasons to be recorded, make an order that the compensation to such amount not exceeding the amount of fine is empowered to impose, as he may determine, be paid by such complainant or informant to the accused or to each or any of them. The magistrate may, by order directing payment of the compensation under subsection 2, further order that in default of payment, the person ordered to pay such compensation shall undergo simple imprisonment for a period not exceeding 30 days. When any person is imprisoned under subsection 3, the provisions of section 68 and 69 of IPC shall so far as may be apply. No person who has been directed to pay compensation under this section shall, by reason of such order, be exempted from any civil or criminal liability in respect of the complaint made or information given by him, provided that Any amount paid to an accused person under this section shall be taken into account in awarding compensation to such person in any subsequent civil suit relating to the same matter. A complainant or informant who has been ordered under subsection 2 by a magistrate of second class to pay compensation exceeding 100 rupees may appeal from the order as if such complainant or informant has been convicted on a trial held by such magistrate. When an order for payment of compensation to an accused person is made in a case which is subject to appeal under subsection 6, the compensation shall not be paid to him before the period allowed for the presentation of appeal has elapsed, or if the appeal is presented before the appeal has been decided. Where such order is made in a case which is not so subject to appeal, the compensation shall not be paid before the expiration of 1 month from the date of the order. The provisions of this section apply to the summons case as well as warrant cases. Trial of summons case by magistrate, section 251 to 259. Summons cases are less serious in nature than warrant cases. Offences punishable with imprisonment not exceeding 2 years are generally listed as summons case. Section 2W of the Code defines summons case as summons case means a case relating to an offence and not being a warrant case. Wow, very good. Chapter 20 containing 251 to 259 of CRPC. 1973 lays down the provision relating to procedure for trial in a summons case. The procedure contains the following stages: explaining the substance of the accusation, section 251, conviction on the plea of guilty, section 252, conviction on the plea of guilty in the absence of accused in petty cases, 253, hearing of the prosecution and defense or procedure when not convicted, section 254, acquittal or conviction, that is section 255, non-appearance or a death of the complainant, that is section 256, withdrawal of the complaint, that is section 257, power to stop proceedings in certain cases, that is section 258, conversion of summons case into warrant case, that is section 259, compensation for wrongful accusation, that is section 250. Explaining the substance of accusation, section 251. In a summons case, when the accused appears or is brought before the magistrate, he shall be informed of the particulars of the accusation. It is not necessary to frame a charge. Omission to state particulars of accusation amounts to irregularity and is punishable under section 313. The court then asks the accused to plead guilty or claim to be tried. Section 251 runs as follows. When in a summons case, the accused appears or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. Conviction on the plea of guilty, section 252. If the accused pleads guilty, the magistrate may convict him. Section 252 runs as follows. If the accused pleads guilty, the magistrate shall record the plea as nearly as possible in the words used by the accused and may in his discretion convict him thereon. Conviction in the absence of accused in petty cases, section 253. If the accused pleads guilty in respect of a petty offence, the magistrate may impose fine even in his absence, and the same may be communicated through messenger or by post. Section 253 read as follows. Where a summons has been issued under section 206 and the accused desires to plead guilty to the charge without appearing before the magistrate, he shall transmit to the magistrate by post or by messenger a letter containing his plea and also the amount of fine specified in the summons. The magistrate may, in his discretion, convict the accused in his absence or in his plea of guilty and sentence him to pay the fine specified in the summons. And the amount transmitted by the accused shall be adjusted towards that fine. And where a pleader, authorized by the accused in this behalf, pleads guilty on behalf of the accused, the magistrate shall record the plea as nearly as possible in words used by the pleader and may, in his discretion, convict the accused on such plea and sentence him as aforesaid. Hearing of the prosecution and defense or procedure when not convicted, section 254. If the accused does not plead guilty, the magistrate does not convict and hears the prosecution evidence, and b. evidence produced for defense and may summon the appearance of witnesses if necessary. Section 254 reads as follows. If the magistrate does not convict the accused under section 252 or section 253, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution, and also to hear the accused and take all such evidence as he produces in his defense. The magistrate may, if he thinks fit, on the application of prosecution or the accused, issue a summons to any witness, direct him to attend or to produce any document or the other thing. The magistrate may, before summoning any witness on such application, require that the reasonable expenses of the witness incurred in attending for the purpose of the trial be deposited in court. Next, acquittal or conviction, section 255. After hearing from both the sides, the magistrate finds accused not guilty. He shall record an order of acquittal. If the accused is found guilty, the magistrate passes a sentence according to law. Magistrate, before convicting the accused for a different offence, should satisfy himself that by doing so, the accused is not in any way prejudiced. In other words, magistrate may convict the accused upon proof of facts only. Section 255 runs as follows. If the magistrate, upon taking the evidence referred to in section 254, and such further evidence, if any, as he may, of his own motion, cause to be produced, finds the accused not guilty, he shall record an order of acquittal. Where the magistrate does not proceed in accordance with the provisions of section 325 or 360, he shall, if he finds the accused guilty, pass sentence upon him according to law. A magistrate may, upon 252 or 255, convict the accused of any offence triable under this chapter, which from the facts admitted or proved he appears to have committed, whatever may be the nature of the complaint or summons. If the magistrate is satisfied that the accused would not be prejudiced thereby, non-appearance or death of a complainant, 256. The complainant shall appear before the court or magistrate on the date fixed for his appearance. If he fails to appear, the accused should be acquitted. In case of death of the complainant, the accused may be acquitted or hearing may be adjourned. Section 256 runs as follows. If the summons have been issued on a complaint, and on the day appointed for appearance of the accused, or any day subsequent thereto, to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused, unless for some reason he thinks it proper to adjourn the hearing of the case to some other day, provided where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, magistrate may dispense with his attendance and proceed with the case. The provisions of subsection 1 shall, so far as may be applied to cases where the non-appearance of the complainant is due to his death. Next, withdrawal of complaint, section 257. According to section 257, a magistrate has a discretionary power to allow withdrawal of a complaint. The complainant may be permitted to withdraw the complaint at any time before a final order is passed under this chapter, chapter 20. Section 257 runs as follows. If a complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there are more than one accused against all or any of them, magistrate may permit him to withdraw the same, and shall thereupon acquit the accused against whom the complaint is so withdrawn. Non-appearance or death of a complainant. 256. The complainant shall appear before the court or magistrate on the date fixed for his appearance. If he fails to appear, the accused should be acquitted. In case of death of the complainant, accused may be acquitted or the hearing may be adjourned. Section 256 runs as follows. If the summons has been issued on complaint, and on the day appointed for the appearance of the accused, or any day subsequent thereto, to which hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused, unless for some reason he thinks it proper to adjourn the hearing of case to some other day, provided that where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. The provisions of subsection 1 shall, so far as may be, apply also to cases where non-appearance of the complainant is due to his death. Withdrawal of a complaint, section 257. According to section 257, a magistrate has a discretionary power to allow withdrawal of complaint. The complainant may be permitted to withdraw his complaint at any time before the final order is passed under this chapter. Section 257 runs as follows. If the complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, magistrate may permit him to withdraw the same, or shall thereupon acquit the accused against whom the complaint is so withdrawn. Power to stop proceedings in certain cases, that is section 258. In a summons case instituted otherwise than upon a complaint, a magistrate of the first class or with the previous sanction of the chief judicial magistrate, any other judicial magistrate may, for the reasons to be recorded by him, stop the proceedings at any stage without pronouncing any judgment, and where such stoppage of proceedings is made after evidence of the principal witnesses has been recorded, pronounce a judgment of acquittal, and in any other case release the accused, and such release shall have the effect of discharge. Conversion of summons case into warrant case. Section 259. Section 259 empowers the magistrate to convert a summons case into warrant case if the offence is punishable with imprisonment for more than 6 months, and if he is of the opinion that it would be in the interest of justice to try such case in accordance with the procedure for trial of warrant cases. Section 259 runs as follows. When in the course of a trial of a summons case relating to an offence punishable with imprisonment for a term exceeding 6 months, it appears to the magistrate that in the interest of justice, the offence should be tried in accordance with the procedure of trial warrant cases. Such magistrate may proceed to hear the case in the manner provided for in the court for trial of warrant cases and may recall any witness who may have been examined. Compensation for wrongful accusation. The compensation under Section 250 of the Code is applicable to summons cases also. Summary trial. Summary trial means speedy trial or without any delay formal proceedings, that is informal manner. Certain cases, both summons and warrant cases, relatively less serious, may be tried summarily. For trial of such cases, the procedure is the same. Summons cases are tried according to summons case procedure, warrant cases are tried according to warrant case procedure, but elaborate recording of evidence is not necessary. Chapter 21 containing 260 to 265 of Crpc lays down the provisions relating to summary case trials. Section 260 empowers the magistrate to try summarily. Section 261 deals with the summary trial by magistrate of second class. 262 deals with procedure for summary trial. 263 deals with record in summary trial. 264 deals with judgment in case tried summarily. 265 deals with language of record and judgment. Magistrate competent to try summarily. Section 260. Section 260 clause 1 of the code empowers the magistrate to try summarily. It runs as follows. Notwithstanding anything contained in this code, any CJM or Metropolitan Magistrate or JMFC specially empowered in this behalf by the court may think, if he thinks fit, try in a summary way all or any of the following offences. Offences not punishable with death, imprisonment of life for a term or a term exceeding 2 years. Theft under 379, 380 or 381 of Indian Penal Code, where value of property does not exceed 2000 rupees, substituted for 200 rupees by Crpc Amendment 2005. Then receiving or retaining stolen property under Section 411 of the Indian Penal Code, where the value of property does not exceed 2000 rupees, substituted for 200 rupees under 2005. Assisting in the concealment or disposal of stolen property under Section 414 of the Indian Penal Code, where the value of such property does not exceed the amount of 2000 rupees. Offences under Section 454 and 456 of IPC. Insult with intent to provoke a breach of peace, Section 104. Criminal intimidation possible, punishable with imprisonment for a term extending to 2 years with fine or both. Abatement of any of the foregoing offences. An attempt to commit any of the foregoing offences, where attempt is offence. Any offence constituted by an act in respect of which a complaint may be made under Section 20 of the Cattle Trespass Act. When in the course of a summary trial, it appears to the magistrate that the nature of the case is such that it is undesirable to try it summarily, and the magistrate shall recall any witness who may have been examined and proceed to rehear the case in the manner provided by this code. Crpc Amendment 2005. Under subsection 1 of 260, magistrate has the discretion to try offences specified therein summarily or in a regular way. It is also proposed to provide that the offence of a theft and other cognate offences, namely offences under 379, 380, 381, 411, 414 of the Code, may be tried summarily where the value of property involved does not exceed 2000 rupees instead of 200 rupees earlier. Summary trial by magistrate of second class, Section 261. The High Court may confer on any magistrate invested with powers of magistrate of second class to try summarily any offence which is punishable only with fine or with imprisonment for a term exceeding 6 months, with or without fine, any abatement or attempt to commit any such offence. Procedure for summary trial 262. In trial under this chapter, procedure specified in this code, a trial of summons case shall be followed except as hereinafter mentioned. No sentence of imprisonment for a term exceeding 3 months shall be passed in the case of any conviction under this chapter, that is not more than 3 months punishment. Recording summary trials. The record of a summary trial is kept in the form prescribed by state government. In the summary trial, a formal charge is not framed nor the evidence of witness is recorded. Magistrate must himself write these particulars in register. He cannot depute that duty to his clerk. Further, he is not authorized to affix his signature to the record or judgment by a stamp. Record should be made at the time of trial and afterwards. Section 263 runs as follows. In every case tried summarily, magistrate shall enter in such form as the state government may direct the following particulars: serial number of the case, date of commission of the offence, date of report of complaint, name of the complainant, name, parentage, residence of the accused, offence complained of, and the offence if any proved. In cases coming under clause 2, 3, 4, subsection 1 of 260 section, value of property in respect of which the offence has been committed, plea of the accused in his examination, finding, sentence, other than the final or the other final order, and the date on which the proceedings have been terminated. Judgment 264. Section 264 provides for judgment in case tried summarily. Section 264 runs as follows. In every case tried summarily in which the accused does not plead guilty, magistrate shall record the substance of the evidence and a judgment containing a brief statement of the reasons for the finding. This section lays down that in every case tried summarily in which the accused does not plead guilty, magistrate must record the substance of the evidence, and the judgment that is delivered must also contain a brief statement of the reasons for coming to a particular finding. Language of record and judgment. Section 265. Section 265 prescribes the language and record of judgment in respect of summary cases. It runs as follows. Every such record and judgment shall be written in language of the court. High Court may authorize any magistrate empowered to try offences summarily to prepare the aforesaid record or judgment, or both, by means of an officer appointed in this behalf by the Chief Judicial Magistrate, and record or judgment so prepared shall be signed by such magistrate. Questions and how to answer. State the procedure followed in trial of sessions case. Explain the procedure of trial before a court of session. Commitment of case of court of session. Answer. Write in detail about trial before a court of session from lecture 15. Explain provisions of Code of Crpc regarding trial of warrant cases. Describe provision related to trial of warrant cases. Write in detail about trial of warrant cases by magistrate from lecture. Describe the procedure followed by summons case. Describe the procedure followed by magistrate for trial in a summons case. Write in detail about trial of summons case by lecture. What is summary trial? State procedure. Write in detail of summary. Plea bargaining. Chapter 21A, 21.A, containing 265A to 265L of the Code CRPC, inserted by Criminal Law Amendment 2005, lays down the provision relating to plea bargaining. Plea bargaining means pre-trial negotiation between accused and prosecution, during which the accused agrees to plead guilty in exchange for certain concessions by the prosecution. Relevant cases: State of Gujarat versus Natwar Harchandji Thakur, 2005. Plea bargaining is an alternative method to deal with huge arrears of criminal cases. It is really a measure and a redressal, as the same has been brought on statute. It has also added new dimensions in the realm of judicial reform. Section 265A deals with the application of Chapter 21A. Section 265B deals with the applicant for plea bargaining. 265C deals with the guidelines for mutually satisfactory disposition. 265D deals with report of the mutually satisfactory disposition to be submitted before court. 265E deals with disposal of the case. 265F deals with judgment of the court. 265G deals with finality of the judgment. 265H deals with power of the court in plea bargaining. 265I deals with the period of detention undergone by the accused to be set off against sentence of imprisonment. 265J deals with savings. 265K deals with statement of the accused not to be used, and section 265L deals with non-application of the chapter. Application of Chapter 265A. The chapter shall apply in respect to the accused against whom the report has been forwarded by the officer in charge of the police station under 173, alleging therein that an offence appears to have been committed by him, other than an offence for which the punishment of death or of life imprisonment or imprisonment of more than 7 years has been provided under law for the time being in force, or magistrate has taken a cognizance of an offence on complaint other than offence for which the punishment of death or life or 7 years is provided for the time being, and after examining complainant and witnesses under section 200, issued the process under 204, but does not apply where such offence affects the socio-economic condition of the country or has been committed against a woman or child below 14 years of age. For purpose of subsection 1, central government shall by notification determine the offences under the law for the time being in force, which shall be the offences affecting socio-economic condition of the country. Application for plea bargaining. 265B. A person accused of an offence may file application for plea bargaining in the court in which such offence is pending for trial. Application under subsection 1 shall contain a brief description of the case relating to which the application is filed, including offence to which the case relates, and shall be accompanied by an affidavit sworn in by the accused stating therein that he has voluntarily preferred After understanding the nature and extent of punishment provided under the law for the offence, the plea bargaining in his case that he has not previously been convicted by a court in a case in which he had been charged with the same offence. After receiving the application under subsection 1, the court shall issue a notice to the public prosecutor or complainant of the case as the case may and to the accused to appear on the date fixed for the case. When the public prosecutor or the complainant of the case or the accused appear on the date fixed under subsection 3, the court shall examine the accused in camera where the other party in the case shall not be present, to satisfy himself that the accused had filed an application voluntarily, and where the court is satisfied as the application has been filed by the accused voluntarily, it shall provide time to public prosecutor or the complainant of the case as the case may be, and the accused to work out a mutually satisfactory disposition of the case, which may include giving to the victim by the accused the compensation and other expenses during the case, and thereafter fix the date for further hearing. The court finds that the application has been filed involuntarily by the accused, or he has previously been convicted by a court in a case in which he had been charged with the same offence, it shall proceed further in accordance with the provision of this court from the stage such application has been filed under subsection 1. Guidelines for mutually satisfactory disposition 265C. In working out a mutually satisfactory disposition under clause A subsection 4 of 265B, that is 265B4A, the court shall follow the following procedure, namely, in a case instituted on a police report, the court shall issue notice to the public prosecutor, the police officer who has investigated the case, accused, and the victim of the case to participate in the meeting to work out a satisfactory disposition of the case. Provided throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by parties participating in the meeting. Provided further that the accused, if he so desires, may participate in such meeting with his pleader, if any, engaged in the case. In a case instituted otherwise than on police report, the court shall issue notice to the accused and the victim of the case to participate in a meeting to work out a satisfactory disposition of the case. Provided that it shall be the duty of the court to ensure throughout such process of working out a satisfactory disposition of the case that it is completed voluntarily by the parties participating in the meeting. Provided further that if the victim of the case or the accused, as the case may be, so desire, he may participate in such meeting with his pleader engaged in the case. Report of the mutually satisfactory disposition to be submitted before the court, 265D. Where in a meeting under 265C, a satisfactory disposition of the case has been worked out, court shall prepare a report of such disposition which shall be signed by the presiding officer of the court and all other persons who participated in the meeting, and if no such disposition has been worked out, the court shall record such observation and proceed further in accordance with the provision of this code with the stage application on subsection 1 265B has been filled in. Disposal of the case 265E. Where a satisfactory disposition of the case has been worked out under 265D, the court shall dispose of the case in the following manner, namely, the court shall award the compensation to the victim in accordance with the disposition under 265D. Here the parties on the quantum of punishment, releasing of the accused and probation of good conduct or of admonition under 260, and were dealing with accused under provisions of Probation of Offenders Act or any other law for the time being in force, and follow the procedure specified in the succeeding clauses for imposing the punishment on the accused. After hearing the parties under clause A, if the court is of the view that 360 or provisions of the Probation of Offenders Act or any other law for the time being in force are retracted, in the case of the accused, it may release the accused on probation and provide the benefit of any such law as the case may be. After hearing the parties under clause B, the court finds that the minimum punishment has been provided under the law for the offence committed by the accused, it may sentence the accused to half such minimum punishment. In case of hearing the parties under clause B, the court finds the offence committed by the accused is not covered under clause B or C, then it may sentence the accused to 1/4 of the punishment provided or extendable as the case may be for such offence. Judgment of court 265F. The court shall deliver its judgment in terms of 265E in the open court, and the same shall be signed by the presiding officer of the court. Finality of the judgment 265G. Judgment delivered to the court under 265G shall be final and no appeal except the special leave petition under Article 136 and writ petition under 226 and 227 of the Constitution shall lie in any court against such judgment. Power of court in plea bargaining 265H. A court shall have, for the purpose of discharging its function under this chapter, all the powers vested in respect of bail, trial of offences and other matters relating to the disposal of case in such court under this code. Period of detention undergone by the accused to be set off against the sentence of imprisonment 265I. The provision of section 428 shall apply for setting off the period of detention undergone by the accused against the sentence of imprisonment imposed under this chapter in the same manner as they apply in respect of the imprisonment under any other provisions of this code. Savings 265J. Provisions of this chapter shall have effect notwithstanding anything inconsistent therewith contained in any other provision of this code. Nothing in such other provision shall be construed to constrain the meaning of any provision in this code. For the purpose of this chapter, expression public prosecutor shall meaning assigned to it under clause U of 2U and includes the assistant public prosecutor appointed under 25. Statement of accused not to exceed 2:2k, notwithstanding anything contained in any law for the time being enforced. Statements or facts stated by the accused in application for plea bargaining filed under 265B shall not be used for any other purpose except for the purpose of this chapter. Non-application of the chapter 265L. Nothing in this chapter shall apply to any juvenile, child, or as defined under 2K of Juvenile Justice Care and Protection Act. Plea bargaining over. Abortive trial. Disposal of criminal cases without full trial. Generally, a criminal case is disposed of with full trial. In other words, trial of a criminal case commences with taking cognizance of an offence by a magistrate and ends with the judgment of conviction or acquittal or discharge of the accused. However, there are certain exceptional cases or circumstances in which normal course of full trial may not be practicable or possible. Hence, the cases are disposed of without a full trial. Some examples. 1. Absence of complainant, section 247, 256. Withdrawal of complaint, section 257. Authorify acquit and authorify convict, section 300. Principle of issue estoppel. Tender of pardon, section 306 to 308. Compounding of offences, section 320. Nolle prosequi or withdrawal from prosecution, section 321. Criminal proceeding barred by period of limitation, 468 and 473. Absence of complainant, section 249 and 256. Complainant is one who sets a criminal machinery or law in motion. When an offence is committed or be committed, any member of the public, in the interest of justice, has a duty to inform or report the matter to the police or may file a complaint with the magistrate. If the matter is complained with the magistrate, it is called complaint, and the person who lodged the complaint is called complainant. The complainant has a duty to deliberately prosecute the trial without absenting himself on all days of the adjournments. Section 249 of the Code deals with the absence of complainant in the trial of a criminal case. If the complainant is absent on the day fixed for hearing of the case, the magistrate has a discretionary power to discharge the accused if the offence is compoundable or the offence is not cognizable offence and the proceedings have been instituted upon complaint and the charge has not been framed. Section 249 confers on the magistrate discretionary power to discharge the accused in the above cases and proceed with the case. It runs as follows. When the proceedings have been instituted upon complaint and on any day fixed for the hearing of the case, the complainant is absent and the offence may be lawfully compounded or is not cognizable offence, the magistrate may, in his discretion, notwithstanding anything hereinbefore contained, at any time before the charge has been framed, discharge the accused. Death of a complainant in trial. Where in the course of a trial for defamation the complainant dies, magistrate need not discharge the accused but can continue with the trial. The case is Balbir Kaur versus Dalip Singh, 1987, Punjab. Such a course would be desirable when the defamation alleged is against the complainant in his public capacity. Again, cases Abdul versus Tin Maung. Non-appearance of or death of a complainant, section 256. Section 256 deals with non-appearance or death of a complainant. Section 256 confers on the magistrate wide discretionary power. The accused should be acquitted when the complainant fails to appear without any just cause. In case of death of the complainant, the accused may be acquitted or hearing may be adjourned. Section 256 runs as follows. If the summons have been issued on the complainant or on the day appointed for the appearance of the accused or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything hereinbefore contained, acquit the accused unless for some reason he thinks it proper to adjourn the hearing of the case to some other day, provided that where the complainant is represented by a pleader or by an officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. The provisions of the subsection 1 shall, so far as they may be, apply also to cases where non-appearance of the complainant is due to his death. Withdrawal of complaint, section 257. According to section 257, a magistrate has a discretionary power to allow withdrawal of a complaint. A complainant may be permitted to withdraw his complaint at any time before a final order is passed under this chapter, chapter 20 of Crpc. The section also makes it clear that the complainant will be permitted to withdraw his complaint against any or all the accused, if there are more than one. Where a case is instituted on a police report, the magistrate cannot exercise his power of acquittal on an application of withdrawal made by the person at whose instance the police moved in the case. Section 257 runs as follows. If a complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the case, and shall thereupon acquit the accused against whom the complainant is so withdrawn. Authorify, acquit and authorify convict. Section 300. Authorify, acquit and authorify convict is a basic principle of natural justice. It means a person once convicted or acquitted shall not be tried again for the same offence. In other words, a person who has been tried for an offence and convicted or acquitted by a court of competent jurisdiction shall not be tried again for the same offence. The above principle is recognized in a fundamental right, double jeopardy, under Article 20, Clause 2 of the Indian Constitution. The expression double jeopardy means punished twice or punishment given for more than once for commission of the same offence. It is based on the common law maxim nemo debet bis vexari, which means that a man must not be put twice in peril for the same offence. Article 20, Clause 2 of Constitution says that no person shall be prosecuted and punished for the same offence more than once. This principle has been enshrined and laid out in Section 300 of the Crpc, which runs as follows. A person who has once been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall, while such conviction or acquittal remains in force, not be liable to be tried again for the same offence, nor on the same facts for any other offence for which a different charge from the one made against him might have been made under subsection 1 of 221, or for which he might have been convicted under subsection 2 thereof. A person acquitted or convicted of any offence may be afterwards tried with the consent of the state government for any distinct offence for which a separate charge might have been made against him at the former trial under subsection 1 of section 220.3. A person convicted of any offence constituted by any act causing consequences which together with such act constituted a different offence from that which he was convicted may be afterwards tried for such last mentioned offence, if the consequences had not happened or were not known to the court to have happened at the time when he was convicted. A person convicted, acquitted or convicted of any offence constituted by any acts may, notwithstanding such acquittal or conviction, be subsequently charged with and tried for any other offence constituted by the same acts which he may have committed if the court by which he was first tried was not competent to try the offence with which he is subsequently charged. A person discharged under section 258 shall not be tried again for the same offence except with the consent of the court by which he was discharged or of any other court to which the first mentioned court is subordinate. Nothing in this section shall affect the provisions of section 26 of General Clauses Act 1897 or section 188 of this code. Explanation: the dismissal of a complaint or discharge of an accused is not an acquittal for the purpose of this section. Illustrations: 1. A is tried upon a charge of theft as a servant and acquitted. He cannot afterwards, while the acquittal remains in force, be charged with theft as a servant and upon the same facts with theft simply or with criminal breach of trust. B. A is tried for causing grievous hurt and convicted. The person injured afterwards dies. A may be tried again for culpable homicide. C. A is charged before the court of session and convicted of culpable homicide of B. A may not afterwards be tried on the same facts for murder of B. D. A is charged by a magistrate of first class with and convicted by him for voluntarily causing hurt to B. A may not afterwards be tried voluntarily causing grievous hurt to B on the same facts unless the case comes within subsection 3 of the above section. A is charged by a magistrate of the second class with and convicted by him of theft of property from the person of B. A may be subsequently charged with and tried for robbery on the same facts. A, B, C are charged by a magistrate of first class with and convicted by him of robbing D. A, B, C may afterwards be charged with and tried for dacoity in the same facts. Section 300, Clause 1 of Crpc says that a person who has once been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall not be liable to be tried again for the same offence, while such conviction or acquittal remains in force. It may be noted here that the term acquittal does not cover the dismissal of a complaint or the discharge of the accused. To invoke the principle of authorify convict or authorify acquit, it is necessary that the accused has to establish that he had been tried by a court of competent jurisdiction. The offence tried by the first court and the offence to be tried now must be the same. The words "the same offence" indicate that the ingredients of the two offences are identical and it is not sufficient if the two offences arise from the same set of facts. State of Bombay versus Ilesapte. Even though the two offences are not the same, still the second trial is barred if it is based on the same facts from which he could have charged on the first trial of the second offence, also under section 221(1), or for which he might have been convicted under 221(2). A person convicted or acquitted of any offence cannot be charged and tried again for any distinct offence for which a separate charge could have been made against him in the former trial itself under 220 clause 1. However, the second trial will be allowed with the consent of the state government under 300 clause 2. A person convicted or acquitted of an offence or constituted by any acts may be tried for any other offence constituted by the same acts, with their consequence which did not occur by the time of the first trial and were not known to the court to have happened, if the court by which he was first tried was not competent to try the subsequent offence with which he is charged, that is, hurt and then murder. For example, when A tried and convicted of causing grievous hurt and the person injured afterwards dies, may be tried for culpable homicide. Culpable homicide is a sessions, hurt is for magistrate. A person acquitted or convicted of any offence constituted by any act may be subsequently charged with and tried for any other offence constituted by the same acts committed by him if the court by which he is subsequently charged, 300 clause 4. For example, a magistrate of the first class may subsequently try A on a charge of robbery on the basis of the same facts because the magistrate of second class is not competent to try the offence of robbery. A person discharged under section 258 shall not be tried again for the same offence except with the consent of the court by which he was discharged or with the consent of any other court to which the first mentioned court is subordinate. Section 300 clause 5. Nothing contained in the above 6 subparagraphs shall affect the provisions of General Clauses Act 1897 or section 188 of the Code. Section 26 of General Clauses Act provides that when an act or omission constitutes an offence under 2 or more penal enactments, the offender shall be liable to be prosecuted and punished by one of those offences only and not for more. In Pakireddy Mastan Reddy versus Sri Srinivasul Reddy, it was held section 300 will not be attracted to continuing offences. In Balbir Singh versus State of Delhi 2007, accused was charged for offences under Tada Act. In this case, proceedings were found by court as non-est in the absence of sanction as required under the Act. It was held that the order passed by the concerned court in that regard, though used the word acquitted, cannot lead to acquittal of the accused. In essence, order could only operate an order of discharge, and if subsequently charge sheet is filed against the accused on obtaining requisite sanction, it was held not to amount to infraction of section 300 of Crpc. In the case Sadhuram versus State of Haryana 1990, there is a divergence of opinion regarding analysis of the sample of food items. The report of public analyst was superseded by the report of Director Central Food Laboratory. The complaint was initially filed by the food inspector on the basis of the report of public analyst, as there was no report of director till that time. Therefore, the magistrate ordered to drop the proceedings till such time the complainant chose to file fresh complaint on the basis of the report of the director. It was held that dropping of the proceedings does not amount to final decision of the case, and thus filing of the second complaint incorporating particulars of the report of the director against the accused was not barred. In Messrs. P.V. Muhammad Barme and Sons versus Director of Enforcement 1993, proceedings were initiated against the appellant under C Customs Act for evasion of tax duty and also under FERA. The appellant was acquitted for the offence under C Customs Act. It was therefore pleaded on his behalf that for the same offence no proceedings could be taken under two acts. It was held that the two acts are operated in different fields. The mere fact that penalty proceedings for evasion of excise duty are ended in favour of the appellant does not take away the jurisdiction of the enforcement authorities under FERA. Doctrine of double jeopardy has no application here. Principle of issue estoppel. The term estoppel is derived from the French one estoupe, which means shut the mouth. The principle of estoppel is based on the principle of equity and good conscience. It is enshrined in the maxim elegans contraria non est audiendus, which means a man alleging contradictory facts ought not to be heard. A man alleging contradictory facts ought not to be heard. Elegans contraria non est audiendus. When a person tells us something, we generally hear him. If he says something different or contradicting, we do not hear anymore and contradict such statement. The principle of issue estoppel is entirely a creature of judicial decision and has not yet been embodied in the code or any other code. When the parties in both cases are the same and the issue and the facts leading to formations are the same, the finding on the issue cannot be agitated again in the second case. This is based on the principle of res judicata. There is no specific direction or legislative role on this principle, but the Supreme Court applied it in a number of cases. Pritam Singh versus State of Punjab 1956. In this case, the accused was tried for possessing a revolver without license and he contended that he did not possess any revolver. He was acquitted, holding that no possession is proved. In a subsequent trial on a charge of murder, it was held that the fact of possession of the revolver on that day cannot be proved against the accused, as the prosecution was bound by the earlier decision on this point and was stopped from proving possession. Tender of pardon, section 306 to 308. Where a grave offence is alleged to have been committed by several persons and there is no evidence to fix up guilt on any one of them, the court resorts to tender and give pardon to one of the accused persons or accomplices. Accomplice means partner in a crime. When an offence is alleged to have been committed by two or more persons, they are called accomplices. If an accomplice turns out a witness for prosecution, he was called approver. Pardon can be made at any time after the commitment of the case but before judgment is passed. Where once a tender of pardon is allowed or accepted, the criminal proceedings against the accused come to an end. Section 306 to 308 Code of Criminal Procedure Code provide for tender of a pardon. Tender of pardon to accomplice, section 306. Section 306 provides for tender of pardon to accomplice. It runs as follows. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or a privy to an offence in which this section applies, the Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation or inquiry into or trial of the offence and the Magistrate of the first class inquiring into or trying the offence at any stage of inquiry or trial may tender a pardon to such person on a condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the commission thereof. This section applies to 1. Any offence triable exclusively by Court of Session or by the Court of a special judge appointed under Criminal Law Amendment Act 1952. Any offence punishable with imprisonment which may extend to 7 years or more with a severe sentence. Every magistrate who tenders a pardon under subsection 1 shall record his reason for so doing, whether the tender was or was not accepted by the person to whom it was made, and shall, on application made by the accused, furnish him with a copy of such record free of cost. Every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court of magistrate, taking cognizance of the offence and in the subsequent trial, if any, shall, unless he is already on bail, be detained in custody until termination of the trial. Where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate, taking cognizance of the offence, shall, without making any further inquiry in the case, commit it for trial to the Court of Session if the offence is triable exclusively by that court, or if the magistrate taking cognizance is the Chief Judicial Magistrate, to a Court of Special Judge appointed by Criminal Law Amendment 52 if the offence is triable exclusively by that court. In any other case, make over the case to the CJM, who shall try the case himself. Power to direct tender of pardon, section 307. Section 307 empowers the court to direct tender of pardon with a view to obtain evidence. It runs as follows. At any time after commitment of a case but before judgment is passed, the court to which the commitment is made may, with the view to obtaining at the trial the evidence of any person supposed to have been directly or indirectly concerned in, or a privy to, any such offence, tender a pardon on the same condition to such person. Trial of person not complying with conditions of pardon, section 308. Section 308 deals with the trial of person not complying with the conditions of pardon, or cancellation, or forfeiture, or tender of pardon. It reads as follows. Where in regard to a person who has accepted a tender of pardon made under section 306 or 307, the public prosecutor certifies that in his opinion such a person has either by willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made. Such person may be tried for the offence in respect of which the pardon was so tendered, and for any other offence of which he appears to have been guilty in connection with the same matter, and also for the offence for giving false evidence, provided that such person shall not be tried jointly with any of the other accused. Provided further that such person shall not be tried for the offence for which giving false evidence except with the sanction of the High Court, and nothing contained in section 195 or 340 shall apply to that offence. Any statement made by such person accepting the tender of pardon and recorded by a magistrate under section 164 or by a court under subsection 4 of 306 may be given in evidence against him at such trial. At such trial, the accused shall be entitled to plead that he has complied with the condition upon which such tender was made, in which case it shall be for the prosecution to prove that the condition has not been complied with. At such a trial, the court shall, if it is a court of session, before the charge is read out and explained to the accused, and if it is a court of magistrate, before the evidence of witness for prosecution is taken, ask the accused whether he pleads that he has complied with the conditions on which tender of pardon was made. If the accused does so plead, the court shall record the plea and proceed with the trial, and it shall, before passing judgment in the case, find whether or not the accused has complied with the conditions of the pardon, and if it find that he has so complied, it shall, notwithstanding anything contained in this code, pass judgment of acquittal. It was held in Suraj Darji versus State of Sikkim that an approver whose pardon has been withdrawn for non-compliance with the condition of pardon, it is in 2016, can only be prosecuted for original offence after it is established that he has not complied with the condition of pardon. It is also made clear that the provisions of section 308 clause 4 and 308 clause 5 requiring approver to be asked as to whether he pleads that he has complied with the conditions of pardon before prosecuting him is mandatory, and non-compliance with the said provision vitiates the trial. The very object of the tender of pardon is to obtain aid of evidence from the person pardoned. With the aid of the evidence of the person pardoned, the offences could be brought home to the rest. That is State of AP versus Ganeshwarao 1963. Offences. Tender of pardon is allowed in respect of the following offences. 1. Offences triable exclusively Court of Session. 2. Offences triable by Court of Special Judge governed under Criminal Law Amendment Act 1952. Offences punishable with imprisonment for a term which may extend to 7 years or with a more severe sentence. In the case of magistrate empowered to tender problem, the magistrate is empowered to tender problem in following cases. 1. CJM and MM is empowered to tender pardon at any stage of the investigation or inquiry into or trial of the case. A magistrate, first up, can tender pardon at any stage, inquiry, trial, but not at the stage of investigation. And only after it comes to the court, he can exercise the pardon can be tendered to such person and accomplice or approver upon condition that he is making a full and true disclosure of the case or circumstance relating to offence alleged to have been committed. Compounding of offences, section 320. A crime is a public wrong, that is an offence against society or community as a whole. Therefore, a compromise between the accused and the injured is not enough to absolve the accused from criminal responsibility. However, there are certain offences which are private in nature and literally not quite serious. The court considers it expedient to recognize them as compoundable offences. According to section 320 Crpc, these offences may be compoundable. 1. Compoundable without permission of the court, 320 clause 1. Compoundable only with the permission of the court, 320 clause 2. Others as non-compoundable offences. Thus, compounding of an offence means settlement of a case dispute between the parties. It is accused or an injured by an agreement. Generally, compounding of an offence is possible in respect of non-serious offences. Section 320 clause 1 provides a table containing the list of 16 offences which were compoundable without permission of the court. Hurt, assault, mischief, criminal trespass, adultery, defamation. All under. The 320 clause 2 of the CRPC provides a table which contains a list of the 6 offences which are compoundable with the permission of the court or like theft, cheating, bigamy. Section 320 clause 1 of the code contains table showing offences punishable under IPC, compoundable without permission or leave of the court. Section 320 clause 1 contains the table showing offences punishable under IPC, which can be compounded without permission or leave of the court. Section 320 clause 2 contains the table showing offences which are compoundable with the permission or leave of the court. Section 320 clause 1 offences punishable under sections of IPC specified in the first 2 columns of the table next following may be compounded by the persons mentioned in the third column of the table. Offence, section and person by whom offence may be compounded. Uttering words with deliberate intent to wound the religious feelings of any person. Section 298. Compoundable, the person whose religious feelings are intended to be wounded. With his consent, they can be compounded. Voluntarily causing hurt. Section is 323. The person whom such hurt is caused, he may compound. Then voluntarily causing hurt and provocation. Section 334. The person to whom the hurt is caused can compound it. Voluntarily causing grievous hurt and grave and sudden provocation. Section 335. The person to whom the hurt is caused may compound it. Wrongfully restraining or confining any person. 341 and 342. Can be compounded by the person restrained or confined. Wrongfully confining a person for 3 days or more. 343. It can be compounded by the person confined. Wrongfully confining a person for 10 days or more. Section 344. The person so confined can compound it. Wrongfully confining a person in secret. 346. The person confined. Assault or use of criminal force. 352, 355 and 358. The person assaulted or to whom criminal force is used. Theft. 379. Owner of the property stolen. Dishonest misappropriation of property. 403. The owner of the property misappropriated. Criminal breach of trust by a carrier washfinger. Section 407. Owner of the property misappropriated. Dishonesty, receiving stolen property, knowing it to be stolen. 411. Owner of the property stolen. Assisting in the consignment or disposal of stolen property, knowing it to be stolen. Section 414. The owner of the property is stolen, can compound it. Cheating. 417. The person so cheated, can compound it. Cheating by personation. 419. The person so cheated by impersonation, can compound it. Fraudulent removal or concealment of property and to prevent distribution among creditors. Section 421. The creditors who are affected thereby can compound it. Fraudulently preventing from being made available for its creditors a debt or a demand due to the offender. Section 422. The creditors who are affected thereby can be compounded. Fraudulent execution of a deed of thereby transfer containing false statement of consideration. Section 423. The person so affected can compound it. Fraudulent removal or concealment of property. Section 424. Person affected thereby can compound it. Mischief. When the only loss or damage caused is loss or damage to a private person. Section 426 or 427. The person to whom the loss or damage is caused can compound it. Mischief by killing or maiming an animal. Section 428. The owner of the animal can compound it. Mischief by killing or maiming cattle. Section 429. Owner of the cattle or animal can compound it. Mischief by injury to works of irrigation by wrongfully diverting water. And only loss and damage caused is loss and damage to private person. 430 section. The compounding can be done by a person to whom the loss or damage is caused. Criminal trespass. Section 447. Compounding by the person in possession of the property trespassed upon. House trespass. 448. Compounded by the person in possession of the property trespassed upon. House trespass to commit an offence other than theft, punishable with imprisonment. Section 451. Compounded by the person in possession of the house trespassed upon. Using a false trade or property mark. Section 482. Compounded by the person to whom loss or injury is caused by such use, counterfeiting a trade or property mark used by another. Section 483. Compounded by the person to whom loss or injury caused by such use. Knowingly selling or exposing or possessing for sale constituting purpose goods marked with counterfeit property mark. Section 486. The person to whom loss or injury is caused. Criminal breach of trust of contract. For 491. The person with whom the offender has contracted can compound it. Adultery. Section 497. The husband of the woman can compound it. Enticing or taking away or detaining the criminal intent of a married woman. Section 498. Husband of a woman and the woman can compound it. Defamation, except such cases as are specified under Section 500 of the Indian Penal Code in column 1 of the table under subsection 2. Section 500. The person defamed can compound. Printing or engraving matter knowing it to be defamatory. Section 501. The person so defamed. Sale of printed or engraved substance containing defamatory matter knowing it to contain such matter. Section 502. Person who is affected. Insult intended to provoke a breach of peace. 504. The person insulted. Criminal intimidation. 506. By the person intimidated. Inducing a person to believe himself to be an object of divine displeasure. Section 508. The person so affected, so induced. Next, Section 320, Clause 2. Offences punishable under sections of IPC specified in the first two columns of the table next following may, with the permission of the court, before any prosecution for such offence is pending, the compounded by the person mentioned in the third column of the table. Next offences. Causing miscarriage. Section 312. Compounded by the woman to whom miscarriage is caused. Voluntary causing grievous hurt. Section 325. The person to whom hurt is caused can compound it. Causing hurt by doing an act so rashly and negligently so as to endanger human life or personal safety of others. Section 337. The person to whom hurt is caused can compound it. Causing grievous hurt by doing an act so rashly and negligently and as to endanger human life or the personal safety of others. Section 338. So that is the person to whom hurt is caused. Next, assault or criminal force in attempting wrongfully to confine a person. Section 357. compounded by the person assaulted or to whom the force is used. Theft by clerk or a servant of the property in possession of the minister. Section 381, the owner of the property stolen is responsible. Criminal breach of trust. 406, the owner of the property in respect of which the breach of trust has been committed. Criminal breach of trust by clerk or servant. 408, the owner of the property in respect of which the breach of trust has been committed. Cheating a person whose interest the offender was bound either by law or by legal contract to a pursuit. 418. The person so cheated, cheating and dishonestly inducing a delivery of property or the making, alteration or destruction of the whole valuable property. Section 420. The person is dead. Marrying again during the lifetime of a husband or wife. Section 494. The husband or wife of the person so marrying. Reformation against the president or vice president, the governor, administrator of the union, and the minister in respect of his conduct and the discharge of his public function when instituted upon a complaint made by public prosecutor. Standard. The person defined can compound it. Uttering words or sounds or making gestures or exhibiting any object intending to insult the modesty of a woman or intending upon the privacy of woman. Section 509. The whom it was intended to insult or whose privacy was intruded upon. Only left. When any offence is compoundable under this section, the abatement of such offence or an attempt to commit such an offence, when such attempt is itself an offence, or where the accused is liable under 34 or 149 of IPC, may be compounded in like manner. When a person who would otherwise be competent to compound an offence under this section is under the age of 18 years, or is an idiot or a lunatic, every person competent to contract on his main behalf, with the permission of the court, compound such offence. Next B. When the person who would otherwise be competent to compound an offence under this section is dead, the legal representative as defined under Crpc of such person may, with the consent of the government, compound such offence. When the accused has been committed for trial or when his body convicted and an appeal is pending, no compounding for the offence shall be allowed without the leave of the court to which he is committed, and as the case may be, before which the appeal is to be heard. 6. High Court of City Civil Court, High Court of Session, acting in the exercise of its power of revision under 401, may allow any person to compound any offence which such person is competent to compound under this section. Number 7. No offence shall be compounded if the accused is by reason of a previous conviction liable either to. No offence shall be compounded if the accused is by reason of previous conviction liable either to enhanced punishment or so a punishment of a different kind for such offence. Compounding of an offence under this sector shall have the effect of an acquittal if the accused with whom the offence has been compounded. No officer shall be compounded except as provided by the section. Next, nolle proregio or withdrawal from prosecution. Section 321. Section 321, Modern Equity, empower the public prosecutor or APP in charge of a case to withdraw from the prosecution of any person at any time before the judgment is pronounced by the trial court. He has no such right to withdrawal at the appellate stage if the office relates to matter connected with the central government, or he may seek the withdrawal only after obtaining permission of the court concerned. The withdrawal from prosecution can be done only with the consent of the court. The court, while granting consent, shall exercise discretion judiciously. When the withdrawal is made before the framing of the charge, the accused shall be discharged. If the withdrawal is made after the charge is framed and no charge is required to be framed under Crpc, accused shall be acquitted. Section 321 as follows. Public prosecutor or APP in charge of a case may, with the consent of the court at any time before the judgment is pronounced, withdraw from the prosecution of any person either generally or in respect of any one or more of the offences for which he is tried, and upon such withdrawal, if it is made before a charge has been framed, the accused shall be discharged in respect of such offence or offences. If it is made after a charge has been framed or when under this code no charge is required, he shall be acquitted in respect of such offence or offence. Provided the above that was against any law relating to matter in which the executive power of the Union extends. Was investigated by Delhi Special Establishment Act, that is CBI. involved in the misappropriation or domestic destruction or destruction of or damage to any property belonging to central government was committed by a person on service of central governance while acting or purporting to act as a discharge of his official duty. And the prosecutor in charge of the case has not been appointed by the central government, he shall not, unless he has been permitted by the central government to do so, move the court for its consent to withdraw from the prosecution, and the court shall, before according consent, direct the prosecutor to produce before it the permission granted by the central government to withdraw the prosecution. Criminal proceedings barred by limitation. Chapter 36 of the code containing section 467 to 473 lays down the provisions relating to limitation for taking cognizance of certain offences. Section 467 defines period of limitation. 468 puts bar for taking cognizance of offence after lapse of period of limitation. Section 469 fixes the time and date from which the period of cancellation shall begin. Section 470 provides for exclusion of time in certain cases. Section 471 provides for exclusion of date on which the court is closed. Section 472 deals with the continuing offence. Finally, Section 473 provides for extension of time of period of limitation in certain cases. Period of limitation. Meaning and definition. It is a general principle of law that time does not run against the crown. The object behind fixing the period of limitation is to insist the parties to institute criminal proceedings within a stipulated period so as to avoid complications. Therefore, the accused who is brought before the court may raise the preliminary plea. Criminal proceedings against him are barred by principle of period of limitation prescribed by law in Karnataka. Section 467 of the code states that for the purpose of this chapter, that is 36, unless the context otherwise requires, period of limitation means the period specified in the section 468 for taking cognizance of an offence. Bar of limitation. Section 468 envisages fair trial and except as otherwise provided elsewhere in this code, no court shall take cognizance of an offence of the category specified in section 2. The period of limitation shall be 6 months if the offence is punishable by fine only. 1 year it is term not exceeding 1 year offence. For the purpose of this section, the period of limitation in relation to offences which may be tried together shall be determined with reference to the offence which is punishable with the more severe punishment. So, the period of limitation is 6 months if the offence is punishable with fine only. 1 year if it is imprisonment for a term not exceeding 1.5 years. Then 3 years it was difficult and punishable with imprisonment for a term exceeding 1 year, not exceeding 3 years. For the purpose of this section, period of limitation. In relation to offences which may be tried together shall be determined with reference to the offence which is punishable with adequate severe punishment or, as the case may be, more severe punishment. Commencement of the period of limitation. Section 469 fixes the date from which the period of limitation in relation to shall commence when it runs as follows. 1. The period of limitation in relation to offender shall continue on the date of the offence, on the day of the offence, and where the commission of the offence was not known to the person aggrieved by the offence or to any police officer, first day on which such offence comes to his knowledge of such person or to any police officer, whichever is earlier, of the future. Where it is not known by whom the offence was committed, the first day on which the identity of the offender is known to a person aggrieved by the offence or to the police officer making investigation of the offence, whichever is earlier. In computing the said power, the day from which the exclusion of time in certain cases, section 470. Section 470 provides for exhaustion of time in certain cases. In computing the period of limitation, the time due diligence, whether a court of first instance or in a court of appeal or revision against the offender shall be excluded, provided no such execution shall be made unless prosecution relates to the same facts and is produced in good faith in a court which form the directive or jurisdiction in another person. Waqf is the institution of where the institution of the prosecution in respect of an offence has been stayed by an injunction order, then computing the period of limitation, the period of commitment of the injunction order, the date on which it was issued or made, and the day on which it was withdrawn shall be cancelled. shall be excluded where notice of prosecution for defense. Where a defense has been given or where under any law for the time being in force, the previous consent or section of the government of AP or any other authority required for intimation of the time required for obtaining such consent sanctions should be excluded. Explanation: in computing the time required for obtaining sanction of the government or any other authority, a date on which was made for obtaining the consent of the sanction or other date of which the government servant authority shall both be excluded. In computing period of limitation, time during which the offender has been absent from India or from any territory outside India within the administration of the central government or has avoided arrest by absconding or concealing himself shall be excluded. In simple words, while calculating the period of limitation, the following periods are excluded. The period during which the another prosecution is diligently carried on, the period of order of stay or injunction granted in institution of prosecution, where notice of prosecution is to be given the period of notice, where previous sanction and our consent is necessary, the court required to obtain such consent and consent or sanction, including the value of application for sanction. The period during which the founder is absent from India, appears from outside India. Period which the offender is absconding or concealing himself. Section 471 deals with the exclusion of the date on which court is reserved. Section 471 reads as follows: where the end of the period of limitation and when the court encloses, the court may continuing offence 472. Section 472 deals with offence. It reads as follows: in case of a continuing offence, a fresh period of limitation shall begin to run every moment after a time during which the offence continues. Extension of period of limitation. Section 473 provides for extension of period of limitation in certain cases. It reads as follows: notwithstanding anything contained in the foregoing, any court may take cognizance of the offence until the expiry of the period of limitation. It is satisfied on the fact that in the circumstances of the case, the delay has been properly examined and that it is necessary to do so in the instances. State amendment. We are about to trials.